Mr. David Burrowes.
Thank you much, Madam Deputy Speaker. Madam Deputy Speaker, I don't know if it's something that's in the water, but Enfield has recently produced constituents who have cases of high national importance and are challenging the legislation or international treaties or indeed guidance. I refer, of course, to my constituent Gary McKinnon, indeed my neighbouring constituent Andrew Simiu, and now, and this is the subject of this debate, in Puddick. Now, Madam Deputy Speaker, I don't wish to entertain the House with the salacious details of this case, which are at times complex, other times bizarre, and frankly, quite frightening. I do, though, wish to explore the principles and practice involved in this case, which no doubt the whole House would be concerned about, and which are indeed fundamental. My primary concern, and one that no doubt the whole House shares, is around that principle of equality before the law. The principle, indeed, that money and wealth should not be used to warp the course of natural justice, and that equality should not be eroded in the age of the internet, and indeed, as we've seen in recent time, the age of super injunctions. First, Madam Deputy Speaker, it would be only right, given that it's the subject of the debate, for me to explain some of the details of the case of my constituent in Puddick. In June 2009, Mr. Puddick became aware that his wife was having an affair with her employer, who is a board member of a large reinsurance firm. He found explicit text messages from this man on her phone, which then led to her confession that the affair had indeed been ongoing for some 10 years. In his emotional state, my constituent began calling clients of this large firm and informing them that their manager had been using company expenses to fund an affair with another employee. When the manager concerned became aware of this, he hired a private security firm linked to his organisation to discredit my constituent and indeed, in course, build a case of harassment. Mr. Puddick received a phone call from the chief executive of this security firm, who reportedly said to my constituent, "Our pockets are deep, we will bury you." How was he buried? Well, in August of the same year, my constituent's home, his office, and indeed his company accountants were raided by 16 officers from the City of London Police Counter-Terrorism and Major Crimes Directorate. They removed his PCs, his mobile phones, laptops, digital cameras, and even his personal sat-nav, and sent all of this equipment to a high-technology crime laboratory for testing. My constituent was subsequently arrested, where he decided not to have a lawyer. He then gave a full frank confession that he made those phone calls to clients, and indeed he apologised at the same time. He was then charged, and charged with that, attached to that were stringent police bail conditions. And then when he attended court on the first occasion, those bail conditions were relaxed by the court, because it became immediately apparent that my constituent, who is a man of good character, that he was someone who was not at risk of committing any act of violence, that he was likely to continue to make any threats of any kind, and the court realised that this needs to be dealt with proportionately. I also understand from my constituent that, to the surprise of the magistrates, the officer in the case, when asked about the evidence that was formed the basis of this case of harassment, was informed that my constituent's wife had not even provided a statement. So despite all the, some would say extreme, many would say disproportionate, and certainly expensive investigations that was very much aligned to a major crime, despite all of that resource, the one witness statement one would expect to come forward did not come. So immediately, any right-minded person listening to this, and certainly listening at the back of that court when Mr. Puddick first came into the public gaze, would have questioned, why is this happening? Well, a trial was set for April the following year. However, before this date, the man who had an affair with Mr. Puddick's wife resigned from his position, and the case was dropped. Well, Mr. Speaker, that may well, you'd have thought, have been the end of it, and it would simply have led to perhaps complaints, as indeed it happened to the Police Complaints Authority, and that would have been processed in the usual way, and indeed we would not have ended up in this position here at 4:15 on a Thursday afternoon discussing this case. Well, Mr. Puddick himself decided for his own reasons that he, one could perhaps understand and have a great deal of sympathy that he was rightly appalled by what had happened, and particularly concerned about the disproportionate actions that he felt the police had pursued. He then set up a blog, www.ianpuddick.com, to which he uploaded a love letter sent to his wife, as well as a video explaining the disproportionate response of the police, and also questioning the actions of the private security firm. Entries of the website www.policeexpenses.com and other similar addresses were redirected to the original blog. And then, seemingly, as far as my constituent was concerned, out of nowhere, he was then arrested again in May 2010, this time not by the local police force, the local detectives, but by the City of London Police Murder Squad. He was told by investigating officers that he could not put this information on the internet. My constituent replied, well, I'm just putting forward information that's true. And then the response, some would say even the chilling response when one's looking at issues of freedom of speech from the police, was apparently this: even if it is completely true, you have committed a criminal offence. Mr. Puddick was subsequently charged, again with harassment, but this time on the specific grounds that he created and distributed 3 websites which were designed to discredit an individual both professionally and personally. My constituent denied all these allegations, and indeed the court case went to the Magistrates' Court, and in June of this year it was put to the magistrates that Mr. Puddick was guilty of harassment, indeed harassment through Facebook, through Twitter and his website. And indeed it's those extra allegations that were made which also contributed it reaching national headlines. It was later proved in court that, in fact, under cross-examination at an early stage, that indeed there was no use of Facebook and Twitter whatsoever. By way of an explanation, I understand an officer from the City of London Police offered the reason that the counter-terrorism and the murder squad were called was the level of distress she believed my constituent was causing through his websites. And as Speaker, one can only surmise just if that a basis for the distress caused by a website, if that was a view taken when looking across the internet at other websites for using the very precious and important resources of the counter-terrorism and the murder squad. And I'm grateful that the Minister of Police is here to be able to particularly take note of that concern. Well, my constituent was finally found not guilty on the charge of harassment on the 17th of June of this year. Well, listening to this extraordinary tale, some may believe that this is simply an operational issue, an issue that really belongs on, as did indeed happen on this case, on the pages of the tabloids, and not in this chamber. However, as I said from the outset of this debate, there is an important and very key point of principle, the principle of equality before the law. And as my constituent has stated on numerous occasions, if this can happen to him, then this can happen to anyone. There are, Mr. Speaker, 2 key points in this case that I'd like to raise and put to the Minister. The first is the issue of the apparent influence of wealth and authority in the implementation of the law. It seems clear that if it were not for the well-connected private security company and the high profile of the business involved, my constituent would not have experienced such a proportionate use of force and response. If there's another reason, no one is aware of it. Indeed, it's interesting that the man who had the affair with Mr. Puddick's wife was even advised by police in Sussex, in the county where he lives, that this was a civil and not a criminal matter. Indeed, anyone looking at this case would say that it seems to be a very reasonable judgment to make. But despite that, the City of London police were approached, and then the raid in May 2009 followed. The second raid almost a year later, following the publication of the blog and website, was also, my constituent argues, based on information that came particularly from the private security firm and outside interests. Well, this week we can go back into history. Indeed, we can go all the way back to AD 43, when we have the first recorded mention of equality before the law, was by Pericles. But we can, and I'm sure, Mr. Speaker, you don't want me to go in detail through all the years of history, we can eventually get to the Magna Carta and other important integral documents to our constitutional law to establish that equality of law is an important principle. But indeed, Pericles himself stated that if we look to the laws, they afford equal justice to all in their private differences, class considerations not being allowed to interfere with merit. I'm sure these words and our fundamental principles based on the Magna Carta and established through international law and treaty obligations would seem to be all but forgotten when the 16 counter-terrorism officers from the City of London Police raided a residential property, seemingly, because this is the cause and concern of my constituent, that it seemed to be in the interests of more powerful and wealthy business interests, which were concerned about the effects on reputation and sought to challenge, as far as my constituent is concerned, who is indeed a mere plumber, the interests of free speech, and from what he would say, the interests of truth. One could have a view about the appropriateness of how he went about it, one could criticise it, one could say that's not what should be done. But the fact that those actions were criminalised to the extent that they were, and that they used the actions they used, and the police decided that they needed to use the resource, the question has to be raised, which is why it's come to this chamber. And this is a fundamental issue of wider context in our legal system. Myself as a practising lawyer is concerned, but it's something that should be of real concern to all honourable members. I don't need to remind this chamber, the House, of the recent super-injunction controversy and the complexity added to them by Twitter and indeed the open platform social media that provides that forum. And I believe the key issue really there in that debate was not necessarily just the affairs and the scandals themselves, but the fact that our legal system sought to particularly support, or indeed some would say protect, those individuals of some privilege who were able through wealth and influence to seek to protect their reputations and indeed their future incomes, regardless in some ways of the consequences and the human collateral that invoked. Under Suka, it seems that my constituent's experience is not indeed a lone one. Since having secured this debate, I was contacted by Dr. Howard Fredrics, who was similarly charged with harassment for a website exposing misconduct, as I understand, by officials at Kingston University. Even though, as I'm also informed, the Kingston Police found no evidence of harassment, the CPS went ahead with a case against Dr. Fredrics, in the same way that the CPS decided not to take account, as I understand, of Sussex police advice, and a case was mounted against Mr. Puddick. In both cases, the common factor would seem to be the case that there was people or institutions of influence, and one would have to say the concept of the rule of law has been challenged. Those are two examples. There may be more, which, due to the underreporting of magistrates' cases, can go unnoticed. But the point of this debate is that it should not go unnoticed by this House and indeed by the government. The disproportionate nature of the response to my constituent's case does raise fundamental questions which I don't believe can be cast aside as an operational blip. It does cast a real shadow over the way we do respond to issues, not least issues of free speech, which become much more complex, but also as important, whether it's on the internet or whether it's outside, offline or online. The issues raised by my constituent's case of free speech, and indeed the way in which the prosecuting authorities enforce, particularly in relation to the internet, are of importance and wider significance. Whether it be through cyber stalking or online harassment, it's important to look at how that is applied and how guidance really does affect these issues. We need to recognise that as far as Mr. Puddick's case is concerned, there was no suggestion that his comments, in fact, on his website were untrue. The prosecution of his comments effectively was the argument that the repetition and spreading of the factual points amounted to harassment. It's important perhaps just to make clear at this stage that I entirely agree with the government's policy and approach in relation to this issue. The case law and policy makes it clear that it's illegal offline as much as it's illegal online. And so when we have cases, and some awful cases that do become apparent, of cyber stalking, they should properly be prosecuted and punishable with the full force of criminal law where it occurs. Indeed, if an individual persistently contacts or attempts to contact a victim, which the court concludes is a course of conduct amounted to harassment, then quite properly the police quite proportionately needs to follow through where the evidence leads them, and prosecution needs to properly follow where it's appropriate. And that should happen regardless of whether this occurs in person or through online social media. I also recognise that there is in place sound guidance in relation to cyber stalking and also in relation to harassment. And I would invite the Minister after this debate to be able to consider that guidance and whether it is fit for purpose, whether it is appropriate, particularly taking account of how it seems to have been wholly misapplied in the case of Ian Puddick. Quite rightly, the government is looking at areas of vulnerability of young people, of those with disabilities who need particular protection when it comes to dealing with internet. And we do need to recognise that we have a particularly strong duty to those people, and it's right that the government, in applying the guidance, is looking in those areas. But we also need to ensure that that fundamental principle of equality of law is being applied across the board. And it's the case, and it's pretty clear from the account that I've given of this case, that the proper guidance and application of that guidance is far removed from what happened in Mr. Puddick's case. He was told that he was not allowed to put up his website because effectively it damaged the reputation of another individual, and that this damage amounted to illegal harassment. Now, since this case has reached the public's attention and particular gaze, several commentators on this case have remarked that should Mr. Puddick have been found guilty, this would have indeed opened the floodgates for a number of other such claims. Indeed, I'm sure honourable members of this House, perhaps in an unguarded moment, would be tempted by the possibility of prosecuting the odd blogger who wrote an article about them that they disagreed with. Indeed, I myself have had an attack website that was constructed against me and dedicated to oppose me, and some would say damage my reputation. And indeed other colleagues would have examples of different actions that have happened. But many of us would also recognise that there is a role in place for the law and also the civil law, and no doubt the law of libel and defamation has a role to play. And I welcome indeed the government's attention and review in the area of super-injunctions, looking at how we can properly ensure that these whole areas of privacy and libel and defamation are brought fit for modern day purpose. But I'd also welcome a proper look at the current CPS guidelines and how they apply in all these different circumstances. And what my call is for a level playing field, a level playing field that has been established over all these years, and for one which this country rightly is proud to promote and to apply. I therefore hope that, on behalf of my constituent, that his case sets a precedent, or perhaps at least a marker, that these websites and blogs should be able to be properly looked at in the whole context of a proper appropriation and proportionate application of guidance and both criminal and civil law. And it's important that in the rapidly developing technology that is online, that we ensure that the government also in its guidance does allow for a proper clarity, so that we don't have situations that happen sadly to the detriment of Mr. Puddick. We also need to be particularly watchful when criminal law is involved. Perhaps they are rare circumstances, we don't know exactly the numbers, but we need to recognise that when it does happen, and did happen in the case of Mr. Puddick, and when it's enforced by the police, and when liberty is lost and other consequences arise, we need to be ever watchful and mindful of the consequences and the serious repercussions, and how it does indeed maybe chip, maybe even take a chunk out of fundamental principles that we all hold dear. So, in conclusion, Madam Deputy Speaker, I must reiterate that the issue in this case is not the affair that some may have been interested in reporting on. It's not indeed about my constituents and the phone calls he made to the clients. It's not indeed concerning the man, and it's not concerning the affair at all. The issue is whether the case has been made by Ian Puddick that there is an influence of large companies, of indeed in this case of private security firms, that has led to indeed a taxpayer-funded police force issuing what some would suggest was a taxpayer-funded crusade. Indeed, it was called an operation. It was Operation Bohan. I'm not quite sure it was Bohan, who's the son of Reuben, but it was called that. An operation was dedicated to this case, seemingly to silence the accusations that he made, because they may harm financial interests. One could argue if the complaint had been made to the City of London Police by an ordinary member of the public, say a plumber, like my constituent, I doubt that it's been estimated £1 million would have been spent investigating and prosecuting this case. It would, I imagine, have been dealt with as a civil matter, maybe if the police had been involved, worthy of a quiet word from them. I say an estimated amount of £1 million. Mr. Puddick himself has been asking questions to find out the true costs, and I'd be interested if it was possible to have an answer at some point, and I know it's not going to be available today, of in fact how much this police and prosecution did cost. It would seem, on the face of it, without any other further information, that Operation Bohan flew in the face of the key principle of equality before the law by seemingly putting the interests of wealthy organisations above the free speech and basic rights of the everyday citizen. I don't say those words lightly. I myself have been involved as a criminal solicitor for now 14 or so years, and have great respect for the rule of law, great respect for our system of justice and how it is properly applied day in, day out, indeed properly applied by police officers and prosecuting authorities. But when there are these cases which seem exceptional, which are totally exceptional, it would seem, in terms of the way power is applied, we need to stand up for our constituents. It is worse for everyone, not just my constituent, that it was a taxpayer-funded operation. My tax-paying constituents, all of them, paid their part for taxes for the anti-terrorist officers, for the high-technology laboratory and the extensive surveillance. Indeed, they also played a part for the Crown Prosecuting Service's seemingly doomed attempt to prosecute Mr. Puddick. What my constituent is concerned about is what he would say is an apparent perversion of natural justice that needs to be identified, it needs to be addressed, and it needs to be appropriately, I believe, challenged by ministers. The government, indeed, the Minister of Police, is rightly big on accountability, and I fully support that. What we need to recognise that actions of the police and prosecuting authorities also need to have accountability, and they need to be brought to account for these particular instances, such as the case of Mr. Puddick, so that we ensure that another innocent member of the public is not awoken by an armed counter-terrorism unit, acting perhaps out of the whims of wealth and power.
Nick Herbert.
Thank you, Madam Deputy Speaker. May I first of all congratulate my honourable friend for securing this debate, and it is a pleasure for me to be responding to it on behalf of the government. I know of my honourable friend's long-standing interest in these issues, and specifically to ensure that freedom of expression is protected. I fully understand the reasons why he seeks to raise the case of his constituent, Mr. Ian Puddick, and his concern about what happened to Mr. Puddick, and I appreciate that he seeks to put the case for his constituent very forcefully, which he certainly did. I want to start off by stating something which I know my honourable friend understands, but it is important to restate, which is that ministers do not have a role in commenting on specific cases or interfering in specific cases. We have a principle in this country of the operational independence of the police, and it is very important that ministers do not seek to direct police investigations or comment on them improperly. It is, however, very important also that we have a proper system of accountability of the police for the actions they take, of course to the law, but more widely, and I'll return to that later. So I'm afraid that I cannot, therefore, comment on the legal aspects of this individual case. But I understand that the City of London Police took the allegation of harassment against Mr. Puddick, the allegation that is, very seriously, and it was investigated in line with national procedures. I also understand that the City of London Police received a complaint last September relating to the conduct of officers involved in Mr. Puddick's arrest on suspicion of harassment in August 2009. However, following a thorough internal investigation, the Force's Professional Standards Directorate found that there was no misconduct. Mr. Puddick was informed of this decision last December and had the right to appeal to the IPCC, the Independent Police Complaints Commission. I do not know whether Mr. Puddick has pursued that course, but my honourable friend may wish to contact Mr. Puddick and help him in that regard, because we have a formal complaints procedure whereby the conduct of police forces can be properly investigated where there's a complaint, precisely to deal with situations where people feel that they have been improperly treated by the police. And by having the IPCC, that means that they can be independently investigated. The force can then be independently investigated, quite separate from government, and it's proper that it should be so. Now, there may be reasons why Mr. Puddick has not taken that course, but I'll give way to my honourable friend.
I'm grateful for the Minister for his response, and certainly I will follow up the details of his complaint. My presumption is that the progress of the complaint was probably subject to the fact that proceedings were ongoing which have only recently been concluded, and he'll now be able to pursue many avenues. I think the problem that he probably has encountered is that the complaint he has is not as usual complaints would be in terms of how there's treated in detention or in terms of on arrest, but more of a systemic issue of an operational decision that was made, which he may find harder to get to truth, but I'd invite the Minister to just make inquiries as why such an operational decision, to the point of operational Bohan, was made, was made on this particular case, on the facts of that case.
Well, my honourable friend is now seeking to draw me into precisely the kind of comment that I am prohibited from making about individual investigations. Nevertheless, it strikes me that this is something that would merit an appeal to the IPCC. I may be wrong about that, and I will make sure that we follow up with this debate with formal advice to my honourable friend, which I will send him, about whether that does remain an option for Mr. Puddick. I should also say that my honourable friend referred to the involvement, I think he said, of counter-terrorist officers in this case, and I know that the media reported that there was an involvement of counter-terrorism officers. I can in fact confirm that the investigation was run by the Force's Major Investigation Team, which, while set up primarily to deal with major crime, occasionally deals with cases outside of this remit to relieve pressure on other departments within the Force. The Major Investigation Team sits within the Serious Crime and Counter-Terrorism Directorate, which may have been the source of some confusion around this case and the suggestion that it was counter-terrorist officers who were involved in the investigation. I know that my honourable friend will agree with me that when the police receive an allegation of a crime or a potential crime, they should consider that properly, and indeed they are required to record it within the rules set out. And the offence of harassment is an offence that can cause great distress to the victim, and the police are committed to responding in a timely manner when they receive such reports. That is, my comments in that respect are not to be taken as an endorsement of the police action in this specific case, but I think that we would all agree with the general principle that it is proper for the police to respond to and investigate such claims. And so far as the role of the Internet is concerned, the Internet, of course, has hugely enriched our lives, and every member of this House is fully aware of its potency, but it can also be a useful tool for those who seek to abuse and intimidate their victims, and it is a source of particular concern to the government that a new opportunity for crime has been created through cyber bullying and stalking and the harassment of victims. And that abuse can continue for long periods of time with no refuge for the person on the receiving end of the harassment, and it can of course involve a much bigger audience, with more people becoming accessories to the harassment by forwarding on offensive messages and images, and it can be very difficult to identify the perpetrator. And so for all of those reasons, the government is very concerned about the growth of this particular form of criminality, and we are seeking to deal with it. I mean, let me be clear that we have no plans to block legal content or websites, and our position is that published material should aim to strike a balance between freedom of expression and protection of the public, and should be proportionate to the potential harm that might caused. In other words, it is important that the action we take, and indeed the action of those who enforce the law, is proportionate, which is precisely the words that my honourable friend used. And we are making progress in this area. There will, in fact, next week be a ministerial seminar on personal harm on the Internet, which is focusing on the two key themes of cyber stalking and hate crime. And it's important that we continue to make progress in this area. Nevertheless, I strongly agree with my honourable friend in the principle that he sets out of equality before the law. It is very important that we have a police force in this country that is impartial, that acts without fear or favour, and he is right to restate that principle. And I also agree with him, and he is correct in saying that I am big on accountability, and so is the government. And we do seek to ensure that police forces are both accountable, of course, to the law for their actions, and they are in this case. And I mentioned the recourse of the IPCC. Should Mr. Puddick believe that the police behave unlawfully in this case, of course, he would also have recourse to legal action. Again, I make no comment on whether that is the case or not, but the police themselves are not above the law. The police should also be accountable for their actions. We do seek to strengthen the democratic oversight of policing. That does not extend to an interference in operational independence, because that principle must remain. But we are going to give directly elected police and crime commissioners an important role in the oversight of police complaints, not to receive complaints directly, because that will still be a matter for the IPCC, but to ensure that forces are generally dealing with complaints properly. I should, however, say that I regret that is not going to be applicable in relation to the City of London Police, which is the one force where we will not be introducing directly elected police and crime commissioners, although I am sure the force themselves and the authority that hold the force to account will be watching carefully in the developments that are taking place in relation to our legislation. Finally, can I just say that on the cost of the investigation, my honourable friend cited the cost of £1 million. I'm not sure whether he thought that was the cost of the police investigation and the Crown Prosecution Service investigation. I'm assured that the City of London Police state that the costs of £1.5 million that were ascribed to this investigation were very wide of the mark, but I'm not able to respond on the specific cost that he suggests for the combined operation of the police and the Crown Prosecution Service, and I'm happy to ask that that information is provided to my honourable friend by both the City of London Police and the CPS. It is important for me to say that the CPS, of course, would have had to have agreed to the charges that were brought before the courts, and would have taken the view that a prosecution was in the public interest in doing so. So the actions that were taken were not just a matter for the police concern, they would also have been a matter for the Crown Prosecution Service. Without trespassing further into the detail of the case, I do want to say that I fully understand my honourable friend's concern about this matter, and indeed respect the fact that he has brought it to the attention of the House. I hope he will understand that I cannot interfere, but I hope I've also provided some useful information, and of course I'll give way.
For his for the Minister's response. He'll be aware, because I've raised it with him before, and he will share the fact that within our justice system what is needed, amongst other things, is information. And indeed, the words of the Victims Commissioner, relentless information is a real driver for change and accountability. And one of these areas is indeed in terms of reporting on cases from magistrates' courts, which often can go unnoticed. And whilst I've raised one, indeed two examples, it's the case in this area as in other areas where the benefits of more information coming through will, I believe, help raise the stakes for accountability and ensure that indeed ministers and others are aware, amongst others, about whether there is a prevalence of these type of cases and actions which could lead to some criticism, indeed some operational changes. So I would ask the ministers to have an eye for that, as well as just just raising one other matter which concerns internet crime, which is subject to the debate, of just welcoming the ministerial involvement in the seminars looking at hate crime, and how that's a real concern. I have a particular area of anti-Semitism, how there's a prevalence in the internet, and I know that ministers are taking on previous work from the previous government in that area as well.
Well, first of all, I strongly agree with my honourable friend about the importance of transparency, and it is the case that the criminal justice system is relatively opaque, and this week the government announced further moves in relation to extending transparency, and one of the areas that we wish to do so is in relation to the criminal justice system. And I am currently working on such proposals, because I believe that justice must be seen to be done. and I hope that he will take a continuing interest in that and encourage the efforts that we are taking. I'm grateful for his support for the action that we're taking in relation to hate crime, and I know that he understands the importance of dealing with this. And that is what I would like to say, Madam Deputy Speaker, in conclusion, in respect of this case and the issues which my honourable friend raises, which it is very important that we and the law strike the appropriate balance here. Free speech is an important freedom that must be protected to the greatest extent possible. But free speech cannot be permitted if there is harm done to others. And the law exists in order sometimes to curtail the operation of free speech where such harm may be done. That is why we have a harassment law. It is right that our law enforcement agencies do focus on areas where people may be bullied, where they may be harassed, where they may be subject to intimidation and threats, and that includes through the new medium of the internet. It is appropriate that our law enforcement agencies take action according to the laws that have been set out by Parliament. It equally behoves those agencies to behave in a proper and proportionate manner.